Good morning, everyone, and welcome to Money Talks with Attorney Coral. I am Attorney Coral Pleas, the host of the show, and this show is sponsored each and every week by Columbia Savings and Loan Association. Thank you, Columbia, for sponsoring this show. I am so fortunate today to have with me in the studio the ladies of AK Experienced Paralegals. This is my team, guys. Um, that helps to run my practice, and particularly as relates to estate planning, although they do it all working with me. But I would like to ask each of you to introduce yourselves and talk about what you do with AK Paralegals. So take it away. Andy, we'll start with you.
So my name is Angelina, and I have 19 years of experience doing paralegal work in estate planning, but different areas of law. And Kelly has 29 years of experience doing estate planning and probate and elder law. We've had the business for 2 years, but we just went full time with it as of September of 2024. And as the case of this is, we've noticed that we wanted to help people and we have the same drive. So we have wanted to help the minorities more than anything, to get their assets in order, estate plan, wills and trusts and stuff. And then that's how we met you, working for you for a year. So thank you very much for backing us and supporting us.
Very thankful.
Yes.
Thank you.
Oh, and thank you guys
Mhm.
for backing and supporting me. I couldn't do what I do with the responsibilities that I carry with Columbia Savings and Loan. I wouldn't be able to manage that on top of the law practice if it weren't for the two of you and all that you bring to the table. So thank you. Thank you for that.
Oh, you're welcome.
You're welcome. We appreciate you.
Yes. So one of the main topics today that we're going to talk about is estate planning. Like, who needs an estate plan? Everyone over 18 needs an estate plan, some sort of document, whether it's powers of attorney, or a will or a trust. And then people who have second marriages, as far as blended families, is also needed an estate plan. Anybody who has minor kids, how are they going to leave their guardians and stuff like that? One of the main things that we get, as me and Kelly have done the business for the 2 years, is a lot of people think that life insurance is everything, and it's not. Me being bilingual, I have found that a lot in the Hispanic community as well. So that is very the most common thing, or they feel that if they don't own any property, that um, that they basically don't need an estate plan because they don't own any property. But you need some sort of document to at least have your personal property distributed, and leave that from people fighting, and have that your family at ease and make it easier for them.
Mhm.
One of the things that I want to touch on is about a revocable trust and an irrevocable trust. A revocable trust is something that you can make changes more than once. You can change the order of who you put in charge of your estate, as well as your powers of attorney. If you're going to give money to charity and stuff like that, that is how you would make those changes, and we would do amendments. An irrevocable trust is something that once you sign it cannot be changed, meaning that you leave somebody else to be in control of your money.
Or your asset,
Or
right?
your
A lot of
asset.
times, real estate is transferred to your irrevocable trust. A lot of times, it's used if there's maybe a cabin that wants to be kept in the family. That an irrevocable trust is used as a tool to keep that in the family without allowing any of the children the ability to, take it out and make changes to it.
Uh,
Absolutely.
and the reason that people need an estate plan is to avoid probate, which is the most important thing. If you have assets over 50,000, or you own property, it needs to be avoided from probate. Which probate is a court procedure that you would need to retain an attorney to start a probate court case with the court, in whatever county that you live in. Which for us, it's easier if you schedule something with us to get your assets in order and have all your questions answered, as we offer free consultations. And more than anything, our office is located in Brookfield, but sometimes we use Coral's office too on Park Place, or we do meet at Columbia Savings and Loans. Whatever is easier for the client. We just want to make it accommodating. If a need to basis, we need to go to their homes, and we do that. Stuff like that.
Yeah, and the feedback that I have is that the clients like coming to Columbia because of it's conveniently located, it's easy
Right.
to park. They're in and they're out. So we offer that. Excuse me, sorry you guys, I'm a little um under the weather today, so I appreciate you coming in and taking the laboring oar of the
Sure.
talking as I'm fighting myself back from this cold that I have. But
Mhm.
yeah, so Angelina, though, you were a little too understated about something though. What I referred to as your superpower. You barely mentioned it, but just talk about that a little bit, because a lot of times I can't count how many times now we've had customers that we service that I would never be able to represent them because I don't speak the language. But your ability to be bilingual it is a superpower that helps distinguish what you do from other people doing similar work. Just talk about that a little bit and what that means to the Hispanic community in particular.
So there's really nobody doing estate planning in Spanish. That's like a big thing for the community. They feel more comfortable when they meet with me and Kelly, knowing that I'm there to assist them and I can speak the language and communicate and get their understanding across. More than anything, like, we want them to understand what they're signing legally, because it will be in English. So something me and Kelly do is we do an outline. I do an outline in Spanish, because when they get the drafts from those documents, I want them to know, to make sure that it is correct the way they want their estate plan in order. So that is like the biggest thing, but they feel more at home and more happy that they can ask all the questions, and just to have somebody that speaks their language and can come to them and be more mobile is like a big thing for them. Like, they're happy about that. And just information, and give them the information that they didn't know about, that they could do, whether they have a social security or an ITIN number. One of the biggest things that me and Kelly have done is we've done like limited powers of attorney. What are limited powers of attorney? Those are documents that if you have minor children and you are to go to, and if you were to go to Mexico, or you were to go to Jamaica and leave your kids here, that person that you pick as your guardian would be able to act on behalf of you for your children, whether it be medical procedures or school or anything that it would do to assist them while you're away. So that's like one of the biggest things that me and Kelly have done.
We can also do the powers of attorney if the kids go to a different country with a loved one.
Yes. Yes. And
Right.
we've also done like um, these travel permission slips, where if they need to, if they're not going with their minor children, and they're just, the parents aren't with them and they're going with an aunt or something, we've also done those type of documents for them to be able to travel with somebody over 18 that is not their children.
Okay.
Mhm.
Okay.
Mhm.
All good stuff.
All good stuff.
Yeah.
Yeah.
Mhm.
Yeah. Kelly, what did you want to say? You look like you've got something you want to say.
Yeah.
I just wanted to touch back on the life insurance is not enough, because we hear that a lot. Life insurance is great. You're paying a monthly premium for your insurance that hopefully is going to bury you, or pay for your funeral or cremation at the end, but it's not an estate plan. So it's not authorizing anyone to make financial, pay your bills or make healthcare decisions for you if you're unable to do that yourself. So these other documents need to go along with life insurance if you have it. And that's, I think, one of the most misunderstood things that we've noticed lately is that they think it's just enough, and it doesn't say where your property goes after your death. Life insurance doesn't say, where your car goes or what happens to your house. It's just a premium, that hopefully you have money left for your children or beneficiaries after your burial and funeral are paid for.
And it also doesn't address if you've got money in a bank account somewhere,
Right.
right? All of that should be taken
Exactly.
into account.
It's not enough, and they need estate planning documents to go along with their policy.
Sure.
And also, with an estate plan, you don't pay a monthly premium. I think that's also another misconception. We have, one fee for our estate planning documents, and that's it. You're not paying a monthly premium for any estate planning documents.
And I was surprised, as I know I heard you say that yesterday, and I was
Mhm.
surprised that people would think otherwise.
Mhm.
But
Yeah.
but you actually have
do.
that.
They do,
Yeah.
and we've been hearing that a lot lately. So I think that we just need to clarify that it's not a monthly payment for estate planning documents.
Hmm.
Yeah.
Or
Mhm.
people think that we have like a certain price list for like they'll be like, oh, how much is a living will, or how much is this, and I'm like, we have to sit down and have a consultation, whether it be over the phone, via Zoom, or in person, to
Right.
try to see what assets, because everybody's assets are different. There's some people that own rental properties or have a business and have their burial and plots and stuff, cemetery stuff put in order, and some people that don't. So that's why. So that is like also very important. So we don't have a set price list. We just tell people that it's a free consultation more than anything.
Okay.
Mhm.
Yeah.
So yeah, so that's a real interesting conversation. It looks like we have a caller that would like to weigh in. Caller, please go ahead with your question.
Yes, good afternoon.
Good
Good afternoon.
afternoon.
And ladies, I want to thank you so very much for being there and sharing your information with the community. My question is, what's the difference between a power of attorney and a living will? Because the last time I checked, a power of attorney was someone that would, you're assigned to do your wishes when you leave this world and stuff like that. But a will is, I don't know what's the difference. This is my question. Excuse me. I'm sorry. I'm over the map. But anyway, ladies, first of all, thank you again for being there. My question is, what's the difference between a power of attorney and a living will? I appreciate that, and thank you.
Thank you.
Thank you.
The power of attorney, there's two separate powers of attorney documents. There's the financial power of attorney, which is used when you're unable to make financial decisions, which would be paying your bills, transferring money, things like that. There's the healthcare power of attorney, which if something happens to you and you are unable to make healthcare decisions,
Mhm.
like I hate to use this, but if you are maybe in a coma and need some medical attention, or if you need surgery, you need to name someone, to be able to talk to the doctors. A living will, we don't do the living will because we do the healthcare power of attorney, and the healthcare power of attorney trumps that anyway. But the last will and testament is a document that expresses your wishes. So you would name a personal representative, and that would be someone that you trust to make your final wishes complete. As far as your personal property, who you would want your personal property, your cars, your furniture, any property within your home, who you would want that to go to, and is also your assets. It would also distribute your assets.
Okay.
Okay. Yeah.
Yeah.
No, I think that's
I
good.
hope that
Good.
answers the question.
Sure.
Yes. Okay.
So another thing that Angelina mentioned was the blended families. We wanted to talk about that today.
Yeah, I'm glad you brought that back because I think that that's a big deal,
It
and
is.
that's an everyday thing. And so
Right.
this is the kind of information that people really need to know. Like what should they consider when it comes to having a blended family situation?
Right. So by blended family, we mean second marriage. And then these both sides are bringing children into a combined blended family. The documents need to be drafted. So normally, at least, everybody wants their children treated fairly at the end. So the documents need to be drafted where if something happens to, say, the husband, then we would want his children to still be created or still be treated equally with the surviving wife's children. So that's just important. There's so many blended families and second marriages that are bringing children, into one family.
Yeah, because I can recall a real life situation that I had with some clients that it was exactly that. They both had prior marriages, they both had minor children, they got married, and then the husband died, and this wife was like, "Oh well, forget about his
Right.
kids." I mean,
Yeah.
she pushed them aside, and the documents that they had pretty much allowed her to do it.
Mm-hmm.
And it was hard for them, and they even tried to drag it out in court, and ultimately she prevailed. It's just the
Mhm.
way the things were written
Right.
previously. So knowing that kind of stuff can happen in real life, there was really nothing to be done. I'm sure
Mhm.
if the husband had known or really thought about that beforehand, he would
Mhm.
have set it up differently.
Right.
But yeah, in the end, his kids lost out.
Right, and that's terrible. And we do see that, but there's a way to make the trust become irrevocable upon the death of one spouse. So either the husband or wife, we can make the trust then irrevocable, so the changes can't be made, so the children continue to be treated equally.
Yeah. And I think
Mhm.
that's it kind of reminds me of a question that you got during your presentation yesterday,
Mhm.
Mhm.
where, he kept asking about, well, why not just have a will, and, and then just say in the will, I want half to my spouse and half to my kids,
Mhm.
and all of that. This is where a trust would be a more powerful instrument to
Mhm.
uphold what your true desires are.
Mhm.
Am I
Yes,
right
that's
about
correct.
that?
Right. So not only does a revocable trust avoid probate, it does what you just said it does, Coral, is that it protects all the children then. So not even with a blended family. I mean, even if there's, kids from the same marriage that you want to be treated equally, that's what a trust comes in handy, because not only does it avoid probate, but it makes sure that everybody's treated equal in the end.
Sure.
And something I wanted to add to what Kelly had said about the powers of attorney on the last question. One of the common things we get when we get calls is, oh, well, I'm power of attorney, but the person already passed away. Powers of attorney documents are only good while people are alive, but they die with them once they pass away.
It is so important that you said that, Angie, because a lot of people don't understand that. People think that once that power of attorney is signed, it doesn't matter. But once the person passes away, yeah, it ends with death. So you
Correct.
got to do what you got to do for thereafter.
And just having the power of attorney at the bank isn't enough either, because that is just that bank. It
Yeah.
doesn't cover all their assets.
Sure. Okay, looks like we have another caller. Caller, thank you for calling. Go ahead with your question.
Yes, excuse me. I want to apologize. When I called earlier, attorney, who you?
I'm attorney Coral Pleas.
I know that's right. And to your guests, I just want to say I apologize. Okay. My question is, what about what everything you just said? What about when a person have an insurance policy and incontestable clauses? Do that still work with what you're talking about when you have something that is called incontestable clauses?
So, okay, so I have to distinguish between the language or a clause in an insurance contract versus
Right.
what they were talking about, powers of attorneys and the
Life
importance of having
insurance.
estate planning, documents. The life insurance contract that's a separate. It's a separate matter.
Yes.
So your question is, I want to try to make sure I understand that there's a clause in the contract.
Because I know sometimes when I used to sell insurance back in the days,
Okay.
they had something that was called incontestable clauses.
Okay.
That, as you know, that means that
If you
if you owe
contest
bills
it,
or
you
something
won't be
like
able to
that,
get. Yeah.
thank you,
Like
thank
a
you,
no contest. Yep.
thank you. Okay, thank you for sharing. Thank you for correcting that with me. But that was my question. What about the incontestable clauses? Does that work when you're talking about having a state, uh, what you was talking about earlier. What about the intestable clauses? How do that work? And
Okay.
thank you so very much, ladies. And I appreciate your being there this morning. And I want to thank you, okay,
Okay.
All right,
Thank
taking
you
thank
my
so
call.
thank you
you.
so much for
Thank
calling.
you.
Okay, well,
You
it looks like we're right on time that we do need to take a break. I appreciate that caller's question. What we'll do is we'll go to break, and when we come back, then I will do my best to respond to that. You are listening to 860 AM WNOV Money Talks with Attorney Coral with my special guests this morning, Kelly and Angelina of AK Experienced Paralegals. And we will be right back after this break.
Donald Trump is out of control, stopping payments for healthcare and food for hungry kids, eliminating the Department of Education, and letting Elon Musk access your most private information. Now Trump and Musk are backing Brad Schimmel because they know he'll let them do whatever they want. Not Judge Susan Crawford. She'll be the check and balance we need to protect us from Trump when he goes too far. That's why we need Judge Susan Crawford on the Supreme Court.
The Republican Party of Wisconsin.
Welcome back to Money Talks with Attorney Coral. I am in the studio this morning with the ladies of AK Experience Paralegals. I've got Kelly and Angelina in the studio with me this morning to talk about all things estate planning related. Before we get back to that, there was a caller that called right before we went to break and was mentioning some questions about incontestable clauses and insurance contracts. And as I understood the question, how does that relate to what we're talking about here today? It doesn't directly relate to what we're talking about today. There may be certain clauses in insurance contracts that have a no contest provision. We have talked about having no contest clauses in estate planning documents and what that looks like. And I actually think I mentioned this a couple of weeks ago because we were talking about the Michael Jackson estate and how there was a no contest clause in one of the documents that. So basically, what it means is this: if you contest that estate planning document, the will, the trust, or whatever it is, if you contest it, that your share or your inheritance can be taken away from you if you contest the terms of that instrument. So that's what it means to have a no contest clause in a document like that. And so people will put a no contest clause in because sometimes they don't want to see their heirs fighting over things. They're saying, look, this, I said what I said and I meant what I said. You get this and you get that. Now if you want to come back and try to contest it, then you get nothing. So that's the hammer behind putting something like a no contest clause in an estate planning document. So I hope that I'm answering that question. But Kelly, is there anything else that you want to say about a no contest clause?
Yeah, the only thing that I would like to add is that if there is fighting and that person doesn't get their inheritance, normally it would go to their children if they had any. So if which would be most of the time grandchildren would end up with that person's inheritance.
Oh,
Yeah.
okay.
So it just follows the bloodline.
Okay.
So
Okay.
mhm.
All right. So that makes sense.
Mhm.
Yeah. Okay, ladies. So what more do you want to talk about with estate planning today? I know there's so much.
So I wanted to add to what Kelly was talking about to the trust, to the revocable trust. A lot of people, there's a section to list specific gifts. What I mean with that is you might have a coin collection or art collection or a ring that from your grandmother that you want to leave to one of your children. A lot of people feel that they have to have all that filled out when they come to meet with us, and that is something that does not have to be listed. There's a page where you can list it at any time, even after you sign your documents, because they're already witnessed and notarized, so that you can list it, sign it, and put and date it yourself. With that being said, also, me and Kelly have gotten calls where people want us to notarize documents from online that they downloaded online, which is a common misconception.
Mhm.
That we say no, we can't download any or we can't notarize any documents that are not drafted by attorney Pleas. More than anything, it has to be drafted by an attorney and stuff like that. So with that, and then we also have what else do they do? Or where if they write they handwrite a letter and they think it's legal, because they don't have much, and they want it notarized, and that's good, and that's not, because you need to have some sort of legal documentation, saying what your wishes are, either drafted by an attorney and stuff like that. So that is like the biggest things that me and Kelly get from that. But also, Kelly wanted to talk about something else.
I did, but there's different requirements too in Wisconsin
Mhm.
that makes a will or any document legal. Like the last will and testament needs 2 witnesses and has to be notarized. So for someone to bring a online will to us that we don't, to be notarized, we don't even know what's in that document. So we just refuse to do it. We're happy to draft new documents, get them reviewed by Coral and have them sign our documents, but we're just not going to witness or notarize anything.
Yeah, and what I was going to add to that before we take the caller that's holding, I was going to add to that's something else that I talked about a few weeks ago, that people will download something from the internet, and then maybe there's something missing from that document. So it's important for the person to come in and say what all their circumstances are. I think the example that I was working with, there was a special needs child involved that was not accounted for with this boilerplate document that they pulled from the internet, but they thought that they were good to go because they had this document from the internet. Whereas if they had come in and sat and talked with a team like ours, the right questions are asked, and then you get to those important details, and then you make accountability for that in the documents that you draft. Oh, there's a special needs child involved. Well, let's make sure we tailor these documents in order to make sure that child is protected, as opposed to something they yank off the internet and then want you to notarize.
Right.
Yeah.
So there's real life reasons for why we as a practice that we don't do that.
Right.
So, okay, so caller, thank you so much for holding. Please go ahead with your question.
And excuse me, ladies, for calling back the third time. I apologize for that.
Okay.
I apologize for that. But ladies, what I was asking about before about the incontestable clauses, I think what I was trying to say, I didn't do a good job for it. But what about the creditors? That's why I was talking about incontestable clauses. If you have creditors, it's going to come at your estate, or whatever the case may be, that incontestable clauses, would that protect people from the creditors? Well, obviously you know what I'm talking about, right?
Yeah, no, and I appreciate it. So I'm going to try to answer the question. I know this is the third question.
I know.
Answered the first two. So this is a different.
Coral?
Yeah, no, and it's fine, but this is a different question. Yet again, so I'm happy to answer. So
I appreciate you. But anyway, excuse me for cutting you off. I didn't mean no disrespect and to the ladies in the audience. But yeah, what about the creditors? That was my main question. I wasn't talking about the family. I'm talking about the creditors. If you owe some money and stuff like that, and you leave this world, is there that protection from that clauses that I mentioned earlier? So excuse me, ladies. I appreciate your answering that as best you can, and thank you for taking my call on a third time.
Okay, and thank you for calling. We appreciate that.
Thank you.
We know that means that you're listening to the show, so thank you. Okay, so here's the deal. A no contest clause is what I described earlier, right? If you try to contest the will, if there's a no contest clause in the will, you may find that you lose your right to recover. We're talking about a will, or whatever the case may be. Now, talking about creditors, that's a separate matter. So let's say let's say you have a trust, and you put your house in the trust, and there's a mortgage on your house that's not paid off, and then you die. Well, that bank still has a right to be paid, right? I mean, you maybe want to transfer the ownership of your home to whoever you designate, but that creditor, which is what the bank that holds the mortgage would be, still has a right to recover. So putting something in the trust doesn't mean that creditors have to go away. And then obviously, if you're just talking about having a will rather than a trust, and the matter goes through probate, well, there's a whole process for creditors have an opportunity to bring their claims to probate court. That's part of the process that has to be dealt with in order for creditors to have their opportunity to have their quote unquote day in court, right? They have an opportunity
Right.
to present their claim against an estate. And if it's determined that it's a claim that's valid, well, then it's got to get paid. If it's a
Mhm.
claim that's not valid or not timely or for whatever reason, well, then it may not get paid. So
Right.
that's just the long and short of it. I mean, creditors don't go away.
Right.
Right.
Did you want to add anything to that, ladies? Or did
I
I?
don't have
No,
anything
no, I
else.
don't have anything. No, I
Okay.
think you
No.
explained it fairly well.
Mhm.
Okay. All
I
right.
agree.
So carry on. You guys are talking about some
Special
good
needs.
stuff.
Oh, did you?
We wanted to touch on special needs trusts. So if you have a child that has special needs, or anyone, a beneficiary that is receiving any government benefits, like even SSI, any sort of disability, you want to put specific language in your trust to make sure that that government benefit they receive is not replaced. You want to supplement that income so that they stay on the benefit, but have extra money to do other things that would not disqualify them from receiving any of the benefits. So there's a couple different ways that information can be put in a trust, a revocable trust. It can be put in an irrevocable trust. And then there's a couple other organizations here in Wisconsin that set up the trusts for the beneficiaries, which could be your children or anyone that you want to leave money to that receives government benefits.
Okay.
Yep. So that money, one more thing is that money that person would receive would be put in a trust after your death. So their inheritance, any money you would leave to that person would go into their supplemental needs trust at your death. And then that would shelter them from losing their government benefits.
Okay.
Mm-hmm. Anything else, Ange?
Here's what I would like for you guys to do. I'd like for you to give the name of your business again and your contact information. Tell people how to reach out to you guys if they would like to have a consultation. Tell them if they mention WNOV, they can have a free consultation with you. So tell them how to get in touch with you.
So the name of our business is A&K Experience Paralegals. And they can call us at 414-313-6625. Again, they can call us again at 414-313-6625. Or they can send us an email at akparalegals@outlook.com. And again, that's akparalegals with an S at outlook.com.
Mm-hmm.
Okay, that's good. So I want to make sure to get that out there, and then
Oh
we'll
yeah, we didn't.
we'll give that information again before the end of the show. But sometimes people are listening, they may be driving, they may say, "Oh, let me write it down now," and may not catch the end. So
Mm-hmm.
we want to make sure that we mention that throughout the show. So you guys, so let's say, all right, I am the general public, and I'm reaching out, I'm calling you. And I say, listen, I'm so confused. I don't know what all this stuff is. What is a will and what is a trust? Like, just if I'm just Joe Public, tell me, educate me a little bit on what
Mhm.
those things are. What do those things mean?
So the way me and Kelly would like to explain the trust, we like to consider the trust as a pot. We like to put in like all your assets, for example, like your house, your any money assets, so like your bank checking accounts, if you have any money market accounts or CDs, any life insurance, and any like retirement accounts, 401ks or IRAs or Roths. And then upon your death, that we help you put all that together. And upon your death, basically that's how the trust will distribute those assets. For your home, we like to do transfer and death deed where we make the trust the beneficiary. So we record that deed while you're alive, but it goes into the trust upon the death of the second spouse or upon the death of the first person. And then it stays off the record. So if anybody was to look up to see if you had a trust, they wouldn't know because it's private and it's off the record. And then that person, upon the death of the second spouse, they would need to, the trustee, whoever you put in charge of your estate, would need to open up an account and get an EIN number to fund how put those all those assets together and distribute it upon how it was written up.
Okay. Okay.
And go ahead.
I think it's important to just touch on the personal representatives and the trustees, because I think maybe we should explain what those people are and what their jobs would be. So if you do a simple will, the personal representative, so you want to name someone that you completely trust for your trustees and your personal representatives. If you do just a will, your personal representative is going to be the person that's going to make sure that all of your wishes are followed through at death. So when you pass away, that person will split up your assets, split up, any money that you have, any personal property that you have, and split it according to how your last will and testament reads. As far as a trustee for your trust, it's the same thing. You want to make sure you completely trust that person. They are going to be splitting up your assets again at the time of your death, making sure your wishes are followed. So you want to name a personal representative, a trustee, and backups of both, so that in case something happens to one or one is unable to act as your personal representative or trustee, then you have a backup.
So, and it's a big responsibility being a personal rep, isn't it, Angie?
Yes.
It is.
I've done it 3 times. So
Mhm.
yes, it's a big responsibility.
Yeah,
Mhm.
so it's important, like Kelly said, to pick someone that you trust
Mhm.
that will take that responsibility seriously and execute things the way you've requested that things be done.
Right.
Yeah, also on what Kelly said as well, if you have minor kids, you need to list guardians. Who do you want to be in charge of your kids if something was to happen to you? Because if you don't have an estate plan or anything listed, then it would go into court for guardianship. So that is something that I wanted to just add to that.
Which we want to avoid with
Avoid.
having estate planning documents. We want to avoid the court as much as we can. So if we can name guardians and trustees in the documents, then that you'll know that your kids are taken care of after your death.
Right.
Mhm.
So, as much as we talk about how important it is to decide what happens to your assets and your properties and other things after death, it's even more important if you've got minor children.
Mhm.
So, with that being said, would you guys say is estate planning only for elderly people, or should relatively younger people consider estate planning as well?
Yeah, it's basically for anybody over 18 needs some sort
Mhm.
of document. If they're over 18, we tell them that if your kid's in college, you're no longer they're an adult. They're considered an adult in the state of Wisconsin, so you wouldn't be able to get any medical information or financial information on their accounts or anything because they're over 18, and that is like very important that the people get done. Some sort of estate planning document needs to be in place.
Yeah,
Right.
yeah.
I mean, my son studied abroad, and I had him sign the powers of attorney before he left. So I was able to get a lease for him. I was able to do his tax returns, transfer money to him. And thank goodness nothing happened to him. So I didn't need the health care. But the financial power of attorney came in handy just for those 3 things I mentioned.
And those are 3 important
And very
things.
important things that I could get done while he was in Spain.
Right.
Mhm.
Right. Yeah, so no, it's really important to have all these types of documents. So we're talking again about like the power of attorney documents. You guys explain the difference between a springing power of attorney and then just like the regular. Just talk a little bit about the difference in those types of documents.
There's immediate and springing, like you mentioned. The immediate, we do probably 90% of the time. And that is because we don't know when something's going to happen to us. So we don't have that magic 8 ball saying something's going to happen to us or what timing it's going to be. So to do the immediate, again, you need to name someone that you completely trust.
But I'm going to back you up to
Yep.
be even more basic. What is an immediate? I know it sounds
Okay.
like exactly what it
It's
is,
okay.
but immediate power of attorney means what?
Immediate power of attorney means it's valid upon signature. So when you sign that power of attorney, your agent or your person that you named is able to write your bills for
right
you.
away.
It becomes effective right away.
Mhm.
Springing becomes effective when you are incapacitated, when something happens to you. The problem with using the springing is that you possibly could need a guardianship along with that. If you're incompetent and you can't, nobody says that you're incompetent, but you think your mother or your father or whoever's doing the document is incompetent. That's not enough. So a guardianship might need to go along with that springing power of attorney. You have to be declared incompetent for it to come into play.
And that's a hassle because that can be a court process that can take time and cost plenty of money and require, the hiring of a doctor to perform an examination.
Mhm.
And then there can be, um, what do you call it? A guardian ad litem having to be
Right.
appointed. Like it can turn into an entire court process
Right.
when you have to go through all of that. And the example that I gave in the show just a few weeks ago was when we talked about some of the elders that maybe there's dementia that's setting in, and maybe
Mhm.
there's some days where they're perfectly fine and
Mhm.
crystal clear and sharp. And
Right.
then the next day, can't find their way from here to home.
Mhm.
And,
Yeah.
and it's real.
Right.
So it can be hard to have someone come and definitively say that this person is incompetent to do certain things.
Mhm.
So that's why it's important to talk about those two different types.
Sure.
But okay, so it looks like we have to take another break here. So we will be right back after the break. This is Money Talks with Attorney Coral. Welcome back. This is Money Talks with Attorney Coral. I'm Attorney Coral Plus, the host of the show, and just want to thank the audience for being so engaged and listening. We can tell by all the calls and all the questions that people are really paying attention to the information that we are sharing, and we appreciate that. I do want to encourage the audience, if you'd like to call in, the number here for the station is 414-444-5250. That is 414-444-5250 or 5253. Today, I'm happy to have in the studio with me the ladies of A&K Paralegals. And it looks like we have a call right now. So thank you so much for calling. Caller, please go ahead with your call.
Okay, my call was two. One is when we got old, we got rid of our life insurance and paid for our funerals. And who gets to decide what little things go on at the funeral? The other question is, we have a trust, and can we look at that and change it if we want to?
Okay. Do you ladies want to answer those questions? Thank you so much, caller. We appreciate your call.
Yeah, so definitely to answer your question, we can definitely do a consultation. You can give us a call. If some of you just tuning in, you've missed some of the information in regards to estate planning, you can definitely give us a call at 414-313-6625. Again, that number is 414-313-6625. And we'll be more than happy to give you a free consultation, and we can review the documentation and see what changes you can make. And for the funeral arrangements, it would be you that would be making those decisions as what flowers you want and stuff. And I know that whatever funeral you have, that is something that they can assist you with that. We would just do an assignment to the plots and grave plots that you have with the cemetery to your trust. So that is something that we can also assist you with. But again, you guys can give us a call at 414-313-6625 if you've just tuned in or missed some of the information, or you have any further questions to discuss.
No, I think that's good. And I was just going to add that, to the point of her question, whether or not she can make changes to her trust depends on the type of trust that it is, right?
Correct.
So if it is a revocable trust, you can make changes. If it is an irrevocable trust, then you cannot make changes.
Right.
So it just depends on the type of document that is. So if you're unsure what type of document it is, that goes to Angie's point that, give them a call at the number that she gave. And they are able to review the documents for you and tell you what type of document it is. Okay. So again, you guys, just again, a quick synopsis of your business, how to reach you, and just let people know what is AK Paralegals and how can you be reached.
You can give us a call at 414-313-6625. And again, it is a free consultation if you mention that you heard us on WNOV. If you have questions for Coral, you can also call us on that number, and we will make sure that if they're legal questions, that Coral will be able to answer them if we're unable to answer them for you. So just give us a call.
All right, ladies, thank you both so much for joining me on the show today. You guys carried it while I'm fighting to get my strength and my voice back, but appreciate you. So thank you, audience. We'll be back next week with more. And before we go, April is Financial Literacy Month, so we will definitely have some special shows coming up on every Thursday for the Money Talks show. The month of April, financial literacy. Stay tuned. We're going to bring some real interesting information for you on those shows. All right, we'll see you next week.